Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
And good morning. This is our weekend review, our analysis, and our discussion of the most important stories in law, in government, and yes, the aspiration for justice in America. Thank you for joining me once again on this bright and bold Saturday morning, February 4th, 2023, in the United States of America. This is a broadcast of Civic Media. We're coming to you from the studios of WAUK Radio in downtown Waukesha. It's The Shot, 540 AM, 101 FM, and in this hour, our 9 o'clock hour, and in the next hour as well. As always, we're going to be taking your phone calls at 844-967-2789. That number, once again, 844-967-2789. I am joined, as I am always on these Saturday morning occasions, by my wonderful professional producer, Calvin, and he and I will take your phone calls, your comments, your perspectives on all of these important issues that, yes, once again, we're going to be talking about this morning. Thank you for joining me. Thank you for joining Calvin and all of the broadcast places of Civic Media statewide. We do, as always, have an ambitious but achievable agenda, a syllabus for this morning's discussion. It should be both informative and hopefully even somewhat inspiring in terms of the things that we as United States citizens, as citizens of the state of Wisconsin, should be doing to ensure the future of the rule of law in the places that we live, the places that we work, and the places that we grow and develop on every single day of our lives. This morning, as always, we're going to spend a little bit of time talking about the past, recognizing some important things that happened today in history, February 4th, of historical pieces, historical dates in our past. And in particular, we're going to be spending a little bit of time talking about something that happened 20 years ago tomorrow on February 5th, talking about that as well. And then our agenda does include a wide-ranging set of topics, again, in the areas of law and justice, the aspiration for the rule of law in America. We're going to begin by talking about the Fourth Amendment this morning and some perspectives on search warrants this morning, both those that we have chatted about at great length in the past, having to do with the search warrant at the Mar-a-Lago residence of the former president way back in August of last year, and more recently, the searches of the residences and one of the businesses of the present president, Joe Biden. We spent some time talking about civics this morning, a little bit of criminal constitutional law, some investigative law under the Fourth Amendment. What is the difference between a search warrant that is authorized by a federal magistrate judge or a district court judge, and what we have seen more recently with respect to consent reviews and consent searches of properties, including those of the present president? We'll talk about that a little bit. And then beyond that, we've got at least 4, if not 5, major stories from different areas of life and of law throughout the state of Wisconsin and the United States of America. We're going to talk about a major ruling coming out of the Fifth Circuit Court of Appeals having to do with the unconstitutionality of a federal criminal statute regarding the possession, the use, the carrying of firearms. It's making a lot of news coming out of one of our appeals courts. We're also going to be chatting again about some January 6th charges and a conviction recently had in a federal district court in Washington, D.C. And then moving all around the country, this past week we saw the release of a Guantanamo Bay defendant, a terrorist who was held in custody at Guantanamo Bay for many years and now released, going to be going to Belize. We'll chat about that. And then we're going to come back to Wisconsin and talk about Kyle Rittenhouse and a wrongful death action that a federal district court judge in Milwaukee, the Eastern District of Wisconsin, recently said can go ahead against him for the deaths in connection with Kyle Rittenhouse's shootings, as we all well recall. And finally, also talking, going back to the East Coast, about Johnson & Johnson and a recent Third Circuit Court of Appeals case basically said that major corporations cannot hide behind the bankruptcy laws and the rules as a way of avoiding the imposition of significant civil judgments if, in fact, they're found responsible for pharmaceuticals and other negligence in the marketplace of America. Lots of different things to talk about this morning. But let us begin, as I said, with a little bit of reference to the past. Some things that happened today in history. All of these, interestingly, have some connection to the rule of law and to the administration of justice in the past and also in the present, right here in the United States of America. Today, February 4th, 1945, World War II was coming to an end. This was the first day of the Yalta Conference. Students of history, those of you who are not students of history but know this, recognize that this was the start at the Yalta Conference of this very important meeting among the leaders: Franklin Delano Roosevelt, United States of America, obviously Winston Churchill, the United Kingdom, and Joseph Stalin of Russia at the time, and all of them getting together to talk about what's going to happen in the post-World War II world, a plan for the final defeat and the occupation of Nazi Germany, beginning to talk about some line drawing, other things that happened in the wake of World War II. The first day of that Yalta Conference, today, February 4th, 1945, I'm going to talk, as I indicated, about another connection to war, this one, the war on terrorism, as we talk about this Guantanamo Bay defendant a bit later in our 2-hour program this morning. Also today, 1974, another major matter, a major news item that attracted not only the attention of lawyers and judges and prosecutors and defense attorneys and investigators, but of all of us. 1974, February 4th of 1974, was the date that newspaper heiress Patty Hearst was kidnapped by a group called the Symbionese Liberation Army. Those of you who were around at that time recall that name well, the SLA. She later appeared in two bank robberies with that group. She was known at the time then as Tanya. An awful lot of people believe, as she confirmed later on, effectively brainwashed, indoctrinated into the views of this group and became one of them, if you will. A lot of focus on whether or not she was engaging those bank robberies voluntarily or if she was coerced. In the end, she was captured by the FBI in 1975, prosecuted by the federal government in 1976 based upon those bank robberies, some firearms offenses, and served some time, about 3 years of a 7-year sentence in federal prison. Interestingly, Jimmy Carter commuted her sentence during the course of his time as president. We have talked a lot on this broadcast about the prerogative of chief executives to issue pardons under the United States Constitution. And then Bill Clinton, during the course of his term as president, issued a full pardon to Patty Hearst, again, during his time as president of the United States of America. So all that happening 1974, 1975, 1976, obviously into Jimmy Carter's term and Bill Clinton's term as well. Again, a major story at that time continues to reverberate to this day when it comes to notions of indoctrination and the ways in which people can, in fact, be brainwashed, if you will, into believing things that are not true. And we're going to chat a little bit about that in connection with a case pending before the Supreme Court down the road and also perhaps today as well. And finally, today in 2004 was a day that something happened that changed forever the landscape, the way in which we communicate with each other, in which we communicate with people we do not even know. This was the day that a website called thefacebook.com was launched by people like Mark Zuckerberg and his colleagues in college at university at the time. It became, of course, the largest social network in the world. And again, raising some questions today about the extent to which providers of online websites and online platforms for discussion of issues, for presentation of ideas, should in fact be held liable for the things that their clients, the people who make use of those platforms, post. A major case pending before the Supreme Court right now on that issue. That language in a statute that removes liability for platform providers is now subject to review by the Supreme Court. So it could very much change not only our understanding of Facebook, but many other platform providers like TikTok and others out there that have provided those kinds of forums for discussion. We'll talk about that down the road as well. I mentioned before that we're going to spend a little bit of time this morning, a bit of commentary from me as well, about something that happened 20 years ago tomorrow, February 5th. 20 years ago tomorrow, 2003, and February 5th. This was a day that a Secretary of State, his name was Colin Powell in the George Bush administration, appeared in front of the Security Council of the United Nations. And why was he there? He was talking about a rule of law issue. And in particular, he was providing information that we know in the end was inaccurate, was false, was premised upon inaccurate intelligence. But he represented to the Security Council, to the United Nations, to the world, what? He represented that a fellow named Saddam Hussein, who was at that time the autocratic leader of Iraq, held weapons of mass destruction. Talked about that 17 different times during the course of about an hour-long presentation, obviously trying to encourage the world platform, nations around our planet to believe that this was true. Colin Powell said that there was hard and credible evidence, not only based upon pictures that he showed, but also some tapes that he played about conversations that the autocratic leader, Saddam Hussein of Iraq, posed a real threat to the safety and security of the nation, of the world. And, of course, we know in the wake of that that was all simply not true. Later on, Colin Powell came back and said he regretted that, but he was relying upon what he thought was reliable security and intelligence information. I raise that today, not only because it was 20 years ago tomorrow that was said, obviously changing forever our own history in America, the history of the world, gave George Bush the cover, if you will, the information base, if you will, even though inaccurate, to invade Iraq. Many of you know that I spent 2 years in Iraq, 2006 to 2008, long after we had invaded, long after we had toppled Saddam Hussein. And the reason that I went there at the time was because I volunteered as a part of an initiative of the U.S. Department of Justice and the U.S. Department of State. And the purpose of that was in the middle of the war, while the war was continuing with respect to all sorts of entities there, trying to establish the rule of law there, working a lot with courts and judges, prisons and police officers, establishing the rule of law. I served as the rule of law coordinator, the Justice Attaché, and did that again in a volunteer capacity, raising my hand to do it, supported tremendously by, of course, the United States of America, even in the wake of a mistake made, nonetheless, a decision to go over there to try to make good on something. And I'm going to talk more about that right after our first brief break here. Come back right here on Morning Cannolis, chatting more about that event 20 years ago tomorrow. We are back. This is our weekly, our Saturday morning analysis, a review, our discussion of some of the major issues in law, in government, and the aspiration for justice in America. Thank you once again for joining me and my producer, Calvin, here on this civic media station. We're accepting your calls, as always, taking your calls, welcoming your calls at 844-967-2789. And right before our first brief break this morning, I was chatting about something that happened 20 years ago tomorrow, February 5th, this proclamation by our former Secretary of State named Colin Powell, who advised the world, confirmed for the world wrongly at the time, that Saddam Hussein in Iraq had weapons of mass destruction, credible evidence of that. Later on, plainly determined that that was not the case. And right before the break, I was chatting about my own involvement in that rule of law issue, which is that in late 2005, I volunteered at the request of the Department of Justice at that time. They were looking for people who'd go to Iraq and try to make a go of the rule of law entities, that is the prisoners and those who are in incarcerative situations there in the prisons there, also working with police, law enforcement to ensure that the integrity of those systems are in place, and especially focusing on courts, process, procedure, the kinds of things that we perhaps take for granted here in the United States of America, always can use improvements and further perfections. At the time, along with a number of other assistant U.S. attorneys, I volunteered to go to Iraq to spend what turned out to be 2 years, 2006, 2008, in the middle of that war, and did what one of the ambassadors at that time said, Ryan Crocker, man for whom I have great admiration, said this is sort of like doing the Marshall Plan in Poland in 1942. The war is still underway, trying to do this reconstruction, this rehabilitation. And although in any enterprise like that, when you go into a war-torn and war-ravaged country, anytime you're doing that kind of activity, great challenges, both in terms of transportation, other issues like that, trying to accomplish things, training, advancement, support of those rule of law tenets, again, prisons and police and courts. Nonetheless, I will tell you that I'm very proud of the work that many of us did at that time, a small handful from the Department of Justice, serving as resident legal advisors at various places around the nation. Again, I served as the rule of law coordinator in the Justice Attaché, working with the State Department, with the Defense Department as well, in trying to promote justice in Iraq. And although the results on that are still very much out, one could make the same argument about the United States of America, that even after our 240 years, the report card is not yet written. Plainly, Iraq continues to be a place of some great instability. There are still places of violence. But today, not because of the things that I did or others individually did, but because of the overall attempts to try to make a go of a situation that was admittedly prompted by bad information, by a wrong advice being given. Today in Iraq, it is a republic, and there is a parliament, there is a prime minister, there are presidents of various areas, there are secretaries. Is it a perfect democratic union? No, it is not, plainly. Still many great challenges there. But again, very proud of the efforts that we made, along with a number of others, to try to instill the rule of law and that sense of justice, things we talk about here on this broadcast every day for about 2 years, 2006, 2008. And so I recall both the wrong decision to go in, and also I would like to think the investment that the United States made in establishing what is a nation today that is a republic where people are voting, and there is some sense, fledgling perhaps, and insecure perhaps, but nonetheless a nation that is no longer run by an autocrat. I know that those kinds of issues can be very controversial. Lots of good discussion about those kinds of things all the time. And coming back to our nation as well, we have a constitution as well, as does Iraq. Our constitution, of course, the oldest one on the face of the planet, also one of the shortest ones on the face of the planet. And it includes a Fourth Amendment that was passed by our first Congress after the acceptance, after the approval by the requisite number of states, and includes a Fourth Amendment that establishes many things, but among other provisions that establish the rights and the prerogatives and the positions of all citizens of the United States, this right to be free from unreasonable searches and seizures. That's the language that James Madison and George Mason and others wrote into our Constitution as a part of the first amendments to that Constitution. I spent some time talking about search warrants this morning because, once again, they've been in the news this past week. Let's focus first upon that news. We know that from just this past Wednesday, that the Federal Bureau of Investigation conducted a search at the vacation home of the present President, Joe Biden, in Rehoboth Beach, Delaware, and that was confirmed by the president's lawyer on Wednesday morning. Investigators of the FBI plainly continuing to look into his possession of classified documents. In previous news, we also know as well that the FBI searched the location of this Penn Biden Center, which was his think tank location after he left the vice presidency in the wake of the Obama administration, and also searched the location of his Wilmington, Delaware home. And all of those searches, you might say, well, gee, was there a magistrate judge? Was there a federal district court judge who issued a search warrant under the Fourth Amendment? And the answer is no. And you say, well, how does that happen then? Well, the answer is that under the Fourth Amendment and under the rules and regulations, the interpretations of that have followed, there's also something called a consent search. A consent search, and that is that if the investigators of the state, local, federal authorities come to my door and ask, can we search your property? Can we search your office? And I give them consent. Usually today it's written down to establish it so that when the lawyers and the judges get a hold of that down the road, they've got confirmation. But that was what was done in this case. A consent search does not necessarily have to be supported by probable cause. It simply has to be a request made by the government to come in and take a look, see if there are documents that would suggest that they should not be there. And we know that in some locations, obviously, there was the finding of some documents, At the Rehoboth Beach location, they did not find any new documents. We're going to talk more about this concept of a consent search, which was the focus of these searches of the present president's locations, and the difference between that and a search warrant issued by a federal magistrate judge with respect to the residence of the former president, Mar-a-Lago, back in August. Stay with us for that discussion. And we are back. We are talking about searches this morning under the Fourth Amendment to the United States Constitution. Doing some civics this morning on Morning Cannolis, talking about the difference between a consent search, which again is conducted by federal or state or local authorities upon the consent of the person who has a privacy right, a privacy interest in the place, the location to be searched, giving approval, giving authorization, if you will, for law enforcement to come in and do the search that they are requesting to do. And again, not necessarily predicated upon a finding by a magistrate judge, not predicated at all, typically, by a finding by a magistrate judge or a federal judge that there is probable cause, that there is evidence of crime in that location, but simply an investigative technique. And if in fact, the owner of that property decides that he or she or it wants to rescind that consent, that can always be done. You can take that back and say, you know what, I've decided not to go ahead with it further. That's what the President of the United States of America and his lawyers have done in recent weeks, including just this past week, again, taking our page from the news at this search of the Rehoboth Beach vacation home of the president, finding in the end at that location no additional documents of a classified nature. But the consent search went along, and law enforcement, now having visited that locations in Wilmington, Delaware, and also the Penn Biden Center in Washington, D.C., finding some documents, some of those disclosed by his attorneys, others, again, identified by law enforcement as a result of this agreement, this cooperation, if you will, between the president saying, yes, indeed, I want to cooperate with the investigators. I want to ensure that these documents are returned to where they should be, and that the investigations of these matters proceed apace, that they proceed upon cooperation with the government. Contrast that approach to what happened last year. Again, over a period of many months last year, these attempts by the NARA, by the National Archives, and ultimately the Department of Justice to obtain from the former president, Donald Trump, what turned out to be thousands of documents, all of them probably not properly within his possession, but well over 100 of them classified in nature. Ultimately, after an unsuccessful attempt to subpoena those documents, to make requests, sort of cordially, if you will, to return those documents, what happened? The U.S. Department of Justice requested of a federal magistrate judge in South Florida for permission to go in and conduct a Fourth Amendment search without cooperation, without that consent that I talked about before. And sure enough, the magistrate judge, as we spoke about this way back in August and other times in the fall, looked at the probable cause to believe that there was evidence of a crime at the location in Mar-a-Lago. He looked at that, as you well know. We talked about the 30 or 40-page affidavit in support of that finding of probable cause. The great majority of that text still not disclosed. Why? Because there's been no criminal prosecution, nothing to disclose there publicly or even to a future defendant. But we know that there was probable cause because a federal magistrate judge said, yes, indeed, there is probable cause, and I'm going to grant you the authority to go in and without consent, without authorization of the owner, the property owner at that point, still to this day, Donald Trump, I'm going to permit you to go in and search that premises by virtue of the authority conveyed by the judiciary, by the court. That's a finding of probable cause. That's what James Madison, George Mason, and others contemplated. No unreasonable searches and seizures. That word unreasonable meaning you can't simply go in and kick the door down. You've got to have the imprimatur of a judge, of a court, who has taken this independent, nonpartisan, non-political look at what you have and made the determination that under the Constitution, there is a basis for doing this.
That's what happened. That's the difference between the search warrant conducted way back in early August of last year and these consent searches being done recently, again, by the FBI, same entities, probably conducted in much the same manner, reviewing various locations, taking a look at papers, documenting them, identifying them, providing inventories of them, and certainly taking those documents that should not be in the possession of the current president and, yes, also the former president. But the predicates for those things, as I've indicated, very, very different in terms of how it is that those law enforcement authorities, the FBI in both cases, get in. So that's our civics lesson this morning from the Fourth Amendment Annals of Law Schools and also right here on our Saturday morning show. We're going to stay in Washington, D.C. to talk about a couple of other significant events that happened just this past week in connection with, yes, once again, January 6th. One involving a newly charged defendant for his involvement in the January 6th insurrection, the riot at our United States Capitol, the attempt to overthrow our government at that time, and also another significant trend that is happening with respect to some, not all, not even a majority of the nearly 1,000 defendants who have been charged and are being convicted, tried, and sentenced for their on-site involvement in what happened on January 6th. Let's start with the first of those two stories. We know, just based upon charges that were issued just this past week, that a retired Chicago Fire Department firefighter, his name is Joseph Pavlik. He's 65 years old. He was in Chicago. He was arrested on Tuesday on a criminal complaint. It was filed in the U.S. District Court in Washington, D.C. And again, a little civics lesson here. You can, in fact, arrest someone on a federal warrant, even though it comes out of Washington, D.C., where that person is located. So that's what happened. You have a federal criminal complaint here charging him with obstruction of law enforcement, knowingly entering restricted grounds, and disorderly conduct. All of those things related to his involvement in the insurrection, the riot of January 6th. U.S. Magistrate Judge Sunil Harjani ordered Pavlik released on bond pending his appearance in the federal district court in Washington, D.C. The Chicago Police Department confirmed on Wednesday that Pavlik had joined the department in 1981 and served as a firefighter there until his retirement in 2013. Now, why is this significant? Well, it's significant because, according to the complaint, that is the information provided in the affidavit in support of this charge against Mr. Pavlik, it makes clear that he is a part of a group called the 3%ers. We've talked a lot about the Proud Boys and the Oath Keepers. Some of those people, as you well know, have been convicted already, are heading towards sentences probably of a significant nature. Others are still on trial even in these weeks. But this fellow, part of a group called the 3%ers, and he made various right-wing statements in the weeks leading up to the Capitol attack, claiming that the election of 2020 had been stolen by then President Donald Trump, and calling for violent action. Again, part of the affidavit in support of his complaint. He allegedly said this. He said, "These aren't Americans. They are indoctrinated socialists that hate America and hate Americans." He said, "We need to be much more brutal than punching and kicking. This is not some simple street disagreement." And of course, regrettably, as we all know, horrifically, what he predicted, that is, Joseph Pavlik wrote on social media, came all too true. We had people who died on January 6th, horrific injuries suffered by law enforcement and others. Specifically, with respect to this particular complaint, the allegation is that Pavlik was a part of some members of this 3%ers group, and they aligned in a faction called Group B, and they supposedly served as security for the protest that, again, was about the certification of the Electoral College vote by Congress. During the course of this review, the investigation of this matter, the charges were that Pavlik and 5 other group members joined a throng of rioters who were trying to force their way past a line of officers who were there at the Capitol. They were defending a place that perhaps many of you have seen if you've been at the United States Capitol. It's called the West Terrace Tunnel, and it provides fairly immediate and unobstructed access, some fairly immediate access to sensitive areas into the Capitol building. This Pavlik fellow, now a criminal defendant in the federal system, and 5 other members of this group had tried to push back, to force their way past this line of officers, that's basically the focus of the criminal complaint. He apparently said heave ho a number of times as these pushes were underway, tried for hours to force the officers back, according again to this complaint. The attempt by these folks to gain access through the tunnel eventually failed, but that is not to say that the attempt was not made. And so that is the basis for the criminal complaint. Pavlik and others will plainly be called upon to answer for those allegations in the future, like the nearly 1,000 other people. And in that connection, we know that those other people, not just in Chicago, not just in Illinois, come from all 50 states in our country, in the District of Columbia, all of those charges coming from the attack on the Capitol on January 6th. We know as well that Pavlik, for what it's worth, is the 37th person from the state of Illinois, to be federally charged as a part of this ongoing investigation. So he takes his position among the ranks of these 1,000 people now charged and presumably going to trial. He could plead guilty or he could go to trial on those allegations. And it is that option, to either plead guilty or go to trial, that leads to our second story coming out just this past week in connection with another defendant in the January 6th case. And this fellow is named Thomas Adams Jr. We have spoken about him in the past based upon obstruction of justice and his attempt to assault the Capitol on that day. Well, this last week, a fellow named Judge Amit Mehta, the judge who's presiding over many of these cases in the district court in Washington, D.C., entertains a stipulated bench trial, which basically means that the parties agree on the facts, and the judge will therefore enter a finding based upon the things that they're presented. It's not quite a plea agreement, but it's pretty close. And in this particular instance, earlier in the week, Thomas Adams said, yes, indeed, I have done this, what's been charged in the complaint, in the indictment against me. And Judge Mehta said that, again, he will sentence him down the road. Well, what happened was that after Thomas Adams made that initial appearance before Judge Mehta and said, yes, I'm effectively going to plead guilty pursuant to this stipulated bench trial, what happened is that Thomas Adams went back to his home state, went back to Illinois once again, Springfield, Illinois, the state's capital, and he went into the media in that location and told the State Journal Register in Springfield, Illinois, this. He said, I wouldn't change anything I did. I didn't do anything, Thomas Adams said. I still to this day, even though I had to admit guilt in this stipulated bench trial, I don't feel like I did what the charge is. So in other words, days after admitting to doing something that plainly is in violation of the federal criminal code, for which he has admitted guilt in front of Judge Mehta in a proper court of the federal government, this fellow goes back and takes it all back, at least publicly. Interestingly, Judge Mehta finds out about this. And in a brief order, just yesterday morning, Judge Mehta said, basically, what's going on here? He gave both sides 1 week to provide reasons why the court should not vacate the defendant's convictions of guilt, as he said, in light of the defendant's post-stipulated trial statements included in the article. He attached actually a copy of the news report to his order, commanding both the prosecution and, most significantly, the defendant, his attorneys, and Thomas Adams in particular, to explain themselves. Plainly, he is unhappy with having taken this plea based upon the statement by Mr. Adams that he understands that what he did was wrong and that he was agreeing to plead guilty to enter into the stipulated bench trial heading toward a disposition. And the case is significant. We'll see what happens, what they submit next week, but it plainly underscores the hypocrisy and the convergence of what many defendants are saying in court as they are presented with and confronted by the specific charges, the possibility of their going to prison for long periods of time. We know some of those defendants have gone to jail as long as 10 years for their involvement. Again, some of those sentences imposed by Judge Mehta himself. But we know that judges hearing these January 6 cases in Washington, D.C. have been repeatedly and increasingly irked by defendants like this fellow for being apologetic and contrite in court, only to be making public statements days later that seem to minimize their guilt and sounding fairly cavalier about their actions. Judges are loath to accept what effectively amounts to a guilty plea from any defendant who doesn't sincerely believe in that guilt, and that's exactly what happened in this particular case. And so we'll continue to follow the case of Thomas Adams and Judge Mehta's response to what he feels plainly is a great disassociation between what Adams said in court and what he is saying publicly. More on that and other stories right after this break. Once again for joining me in this first hour of Morning Cannolis, talking about the important stories in law and government, the aspiration for justice in America. I promised at the top of this hour that we would get to at least 4, if not 5, other major stories of just this past week in that category. And indeed, let's start with the first of those, and that has to do with a federal appeals court. A federal appeals court, the Fifth Circuit, which is basically the South, Texas and Alabama and Mississippi, the district courts in those states together form the Fifth Circuit. The Court of Appeals there is responsible for hearing reviews for challenges to decisions made by lower courts. And this past week, the Fifth Circuit, which is a notoriously very, very conservative court, I think anyone who reviews their decisions in recent times would recognize that, regardless of what side you are on the political aisle. Fifth Circuit, a very conservative court, and indeed lived up to that reputation just this past week. This very conservative appeals court, the Fifth Circuit Court of Appeals, again, one court below the United States Supreme Court, one court above the district court, the trial courts in those states, has found unconstitutional a federal law, long-standing on the books. I used to enforce it as an assistant U.S. attorney and as a United States attorney, frequently used by current and continuing prosecutors in our federal system, a federal law that prevents domestic abusers from possessing firearms. And this particular court, the Fifth Circuit Court of Appeals, called the statute an outlier that our ancestors, our historical ancestors in this land and perhaps others, would not have accepted. So what is this all about? Well, again, it's a panel of the United States Court of Appeals for the Fifth Circuit that ruled on Thursday, just a couple of days ago, in a case called United States versus Rahimi, R-A-H-I-M-I. And this is a significant matter. Again, it appeals. The appeal affects plainly the imposition and the invocation of this particular statute, which we're going to describe right now. Section 922 of Title 18 of the United States Code bars individuals, bars anyone in this country from possessing guns, firearms, if they are, quote, subject to a court order that restrains them from harassing, stalking, or threatening an intimate partner. Basically, domestic violence, right? You can't own a weapon, you can't own a firearm if indeed you are harassing, you're stalking, you're threatening an intimate partner. That's what the law says. Section 922 of Title 18 of the United States Code, in place for many, many years. So what happens here? This fellow named Zakeh Rahimi became the subject of a February 2020 civil restraining order, okay, after his girlfriend accused him of assaulting her. Rahimi consented to the order, which prohibited him in this civil proceeding from harassing or stalking or threatening his ex-girlfriend and their child, and also significantly prohibited him from possessing a firearm. All of that done in February of 2020. Despite that restriction that was imposed upon him, he was involved in 5 Texas shootings between December 20th and January 2021. In one of those, he fired multiple shots into the residence of someone to whom he had sold narcotics. The next day, he was in a car accident. He shot the driver in the other car, fled the scene, returned to another vehicle, and shot the other driver's car. A few weeks after that, Rahimi shot at a constable's vehicle, and 2 weeks after that, he fired multiple shots into the air after his friend's credit card was declined at a restaurant. So this man is on a rampage, right? When law enforcement caught up with Rahimi while executing a warrant, they found a rifle and a pistol at his home, not surprisingly. And then Rahimi was charged in the federal district court and convicted of unlawfully possessing a gun, again, in the wake of this domestic violence order. Rahimi challenged his conviction on the grounds that the law, the Section 922, was an unconstitutional violation of the Second Amendment, challenging something that's been in place for a very long time. And indeed, in the end, this three-judge panel from the Fifth Circuit agreed with him and said that, the law is in fact unconstitutional. Who are these folks? There's a judge named Edith Jones. She was appointed by Ronald Reagan many years ago, and two appointees from former President Donald Trump. Their names are James Ho and Corey Wilson. Wilson took issue with what he described as the government's limited view of the Second Amendment's applicability. He wrote this. He said, "The words 'the people' in the Second Amendment means all members of the political community, not an unspecified subset. Rather, everyone in the national community," he said. I went on to explain that when the Supreme Court referenced law-abiding responsible citizens in its previous decisions, a case called Heller and one more recently called Bruin, it did not actually mean to allow states to strip individuals like Rahimi of their right to bear arms. So a very significant decision coming out of this three-judge panel. The court went on to say Rahimi, while hardly a model citizen, is nonetheless a part of the political community entitled to the Second Amendment's guarantee, all other things equal. And again, I mentioned this case just out of the last Supreme Court term called Bruin. It basically said that under the Second Amendment, we now have a constitutional right, believe it or not, to own and possess and presumably use weapons beyond our homes, beyond just for personal safety. And the panel basically said that under Bruin, again decided by the recent Supreme Court, gun regulations can only stand if they line up with historical analog. Again, this reference to the past as a way of understanding and imposing sentences and rules and laws in contemporary America. The panel, this three-judge panel, searched for some historical parallel, again, upon the invitation of the Supreme Court in Bruin, and it came up apparently empty-handed. The court rejected the argument of the Department of Justice that the English Militia Act of 1662 prohibited dangerous persons from keeping guns, and also some colonial regulations disarming disloyal individuals were similar enough to Section 922 to satisfy Bruin. And so they found the entire law unconstitutional, vacated this conviction, and found that indeed the case was improperly charged. Significantly, Attorney General Merrick Garland has sounded the bell on this. He said Thursday night this. He vowed to appeal the Fifth Circuit rulings. He said, nearly 30 years ago, Congress determined that a person who is subject to a court order that restrains him or her from threatening an intimate partner or child cannot lawfully possess a firearm. He went on to say, whether analyzed through the lens of the Supreme Court precedent, this Bruin case, the Heller case many years before that, or of the text of the law itself, the history, the tradition of the Second Amendment, that statute, the Attorney General said, is constitutional. Accordingly, he said the department will seek the further review of the Fifth Circuit's contrary decision. And again, since this recent ruling of the Supreme Court in Bruin, multiple gun-related cases around the country have been testing the limits of this precedent involving New York cases, D.C. cases, including things over this sensitive location. That coming out of the Fifth Circuit just this past week, a stunning argument coming from the Court of Appeals. We'll see what happens down the road. Stay with us for further discussion of the rule of law here in America in our second segment on this morning, February 4th, 2023.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
This is the second hour of our time together, our analysis, our review, our discussion of the most important stories in law, in government, and the aspiration for justice in America. Thank you so much for joining me in this second hour, this Saturday, February 4th. We are taking a survey through many of the important stories of this past week, and in this hour, from a previous week, related to the imposition of justice, the pursuit of law in America. And right before our break, at the top of the hour, we were talking about this trend involving defendants in the January 6th insurrection, the riot, of confessing, of acknowledging in court that they have, in fact, understood that what they did on January 6th, the assault on the Capitol, about 1,000 of them altogether, was, in fact, in violation of the law, and then going out there and telling media and telling other sources, other public venues that, in fact, they don't believe any of that they still feel very strongly about the rightness of their decision. And the fact that judges are beginning to push back on that and beginning to rescind, if you will, the convictions that were entered and telling them that they can't have it both ways. And that is a good news story for the rule of law. We'll watch that down the road. And right before the top of the hour break, we were also talking about this highly disturbing, very, very concerning decision coming out of the Fifth Circuit Court of Appeals that says that a federal law, 18 U.S.C. Section 922, which bars individuals, people, from possessing weapons if they're subject to a domestic violence prohibition or restraining order for harassing, stalking, or threatening an intimate partner, that you can't hold weapons. You can't possess weapons. It's been the law in the United States for a very long time. People convicted of it appropriately as a way of promoting our safety and security. The Court of Appeals, again, in this case, just last week, called the United States versus Rahimi, found that Mr. Rahimi's conviction premised upon that statute could not stand, invoking the case of Heller, a decision written by Justice Antonin Scalia many, many years ago, and a more recent case called Bruin, written by Clarence Thomas just this past summer, that both of those cases that look back in time, look back in history, to try to support the legitimacy of a current contemporary statute. Fifth Circuit Court of Appeals, a 3-judge panel, finds they can't do that. And so rules unconstitutional this statute that draws a line between domestic abusers and other people and says you can't own a weapon if indeed you are a domestic abuser, and says that's unconstitutional. The United States Department of Justice appropriately says we're going to pursue this. We're not going to let this stand, and the Attorney General committing to an appeal to the United States Supreme Court on this issue. So it will come up again. Rahimi is the name of the case. Again, a matter for concern by all Americans who are concerned about safety and security. This is the kind of thing that courts do when they undermine our basic understanding, not only about the law, the criminal law, but about our need to ensure that this gun violence in America is stopped, that we don't have this continuing problem, not only with mass shootings, but other abuses and misuses of firearms. The Second Amendment does not contemplate the kinds of things that Mr. Rahimi did, and the Fifth Circuit ruling should, in fact, be subject to review and reversal by the United States Supreme Court. We'll see if they take that case on and tell the Fifth Circuit and the rest of us that 922, that prohibits people who are engaged in domestic violence, should, in fact, be prohibited from possessing, using firearms, that should remain the law of the land as it has been. This hour, we're going to continue with that discussion about many important issues in the news. And again, as always, we invite your phone calls at 844-967-2789. My producer, Calvin, and I are interested in soliciting, encouraging your thoughts, your comments, your questions, your perspectives about these and other items of news. Let's go from the Fifth Circuit to a place further south, but not too far further south, on the Cuban island, and in particular, the Guantanamo Bay Naval Base. Guantanamo Bay, we haven't heard a lot about that recently. Recall well that during the campaign for the presidency many years ago, Barack Obama committed to shutting down, to closing down Guantanamo Bay as what he viewed as an unconstitutional place of detention. And the reason for that is just this. And this by way of background with respect to one of the defendants who's been held there for a very, very long time, who was in the news this past week. We're going to talk about him in just a moment or so. Turns out that for many, many years, the Pentagon our Department of Defense has placed in this Guantanamo Bay off-site, non-domestic facility. It is not a part of the Department of Corrections. It is a naval base. Placed many, many prisoners at that Guantanamo Bay detention facility who the Pentagon, the Defense Department, has identified as terrorists, people who are threatening the safety and security of our nation and of other nations. And the challenge that these folks pose is just this, that the information that provides the basis for the Pentagon to incarcerate, to detain these people at Guantanamo Bay is most often acquired, is secured by virtue of intelligence, by secure intelligence that cannot be disclosed into the public domain. And for that reason, these individuals, based upon the assessment of the Pentagon, are so sufficiently dangerous that they cannot be released into the public, whether it's here in the United States or in another place, but nor can they be tried in a federal district court in mainland America based upon their terrorist activities. And we have seen, as you know well, we have seen domestic prosecutions of individuals for terrorism. In these instances, these more than handfuls of people, large numbers in the past of people, again, threats to our national security, our international security, but cannot, by virtue of the mechanisms by which that information has been acquired, can't produce that in a federal district court such that we can go ahead and prosecute them in that public domain. So the question is, what does one do then? What does a civilized nation do with these people? Well, many of them have been relocated over time, and that is the story of one of these individuals who came into the news just this past week. As late as this past week, about 34 prisoners still fall into that category. They're still at Guantanamo Bay, and they are once again in this category of people cannot be brought into federal district court, charged with federal crimes for their terrorist activities because of the nature of the intelligence that identified them in the first place. Of those 34, 11 of them have been charged in military commissions. And again, an awful lot of controversy about that in the public domain, including 6 of those who are awaiting capital trials, okay? So that is among the 34 of those detainees right now at Guantanamo Bay. 3 others, all former CIA prisoners, are being held as indefinite detainees in what is called our continuing war on terrorism. Again, underscoring this great difficulty of what one does with someone who falls into this category. They're not accused of any crimes in our federal district courts, but they're considered simply too dangerous to release. Of the other 20 men or so, half of them from the nation of Yemen, have been approved for transfer to some other countries. In other words, we have now determined that they are no longer the threats that they otherwise were, with security agreements that satisfy the Secretary of Defense, the Pentagon, and arrangements that have been made that require some very complex diplomatic situations. And that leads us to the news that was in the news just this past week. We know, again, that an individual named Majid Sukat Khan, K-H-A-M, he's 42 years old, will now be released from Guantanamo Bay among those 34 detainees held there for a long period of time, released to the authority of custodies in the nation of Belize. You may recall, you may know that Belize is this country in Central America, known perhaps for its barrier reef, beautiful nation, its ecotourism, that sort of thing. And the country of Belize has agreed to take Mr. Khan upon his release from Guantanamo Bay. This small Central American nation moving now to accept Mr. Khan post his incarceration at Guantanamo Bay. Many other prisoners, again, released in the recent years, have been repatriated. Mr. Khan, who actually completed his prison sentence nearly a year ago, quite literally had nowhere to go. And upon the news this past week that he will be moved to Belize, the nation taking him out of this Guantanamo Bay detention, he said this. He said, "I've been given a second chance in life, and I intend to make the most of it and to become a productive, law-abiding member of society." He said, "I continue to ask for forgiveness from God and those I have hurt." And that statement underscores both the difficulty of the Guantanamo Bay detainees and the situation there, but also the difficulty in figuring out what one does as a just and fair nation, the United States of America, what you do in these circumstances. Mr. Khan was perhaps among the better known of these detainees at Guantanamo Bay, among other things. He went to high school in Maryland, left his immigrant family for his native Pakistan, and then that's when he got into trouble. He joined Al Qaeda after the attacks of September 11th of 2001. From about 2006 to 2003 to 2006, he was in some secret CIA prisons overseas and kept in some dungeon-like conditions. And this is the part of the story that also is very troubling, not only for our nation's present review of these detainees, but its recent history as well. Mr. Khan, during the course of his detention by the CIA, was beaten. He was brutally forced some feedings, waterboarded, other physical and forms of even sexual abuse. Eventually, he agreed to testify against other prisoners. He agreed. He did, in fact, agree to plead guilty to plotting a never-realized suicide bombing years earlier involving Pakistan's president. And so he agreed to this particular crime. And he also delivered $50,000 that we used to finance a deadly attack in Indonesia. And so we have this person, Mr. Khan, who is both engaged in plainly terrorist activity, probably involved in other activities, but also subject inappropriately to treatment by our own forces in that location. Well, Mr. Khan now being released, the government of Belize, the ministry there saying, although Mr. Khan has contributed to many acts of terrorism, he was also brutally abused and tortured, has repudiated radicalism, cooperated with U.S. authorities in the fight against terrorism, and has served his time. So overall, this balancing resulting this past week in Mr. Khan being moved to Belize, one among the 34 still in Guantanamo. A continuing story this morning and in the future. Join us, continue to stay with us right after this break as we talk about more stories in the rule of law in the United States of America.
We are back, continuing on this great Saturday morning to discuss a number of different items in the news that underscore important lessons, important instruction about the rule of law in America, the way in which we live, the way in which we understand our system of justice, and the things that we should expect from our courts, our police, our law enforcement authorities, all representatives of government, and the lawyers who are also in court on a regular basis. And that takes us to our next story this morning. It involves Kyle Rittenhouse. Kyle Rittenhouse, many of you know well. He is this Chicago-based, Illinois-based young man who was accused back in August of 2020 with shooting three men, two of them fatally, during the horrific civil unrest in Kenosha, Wisconsin. At his trial in November of 2021 in the state court in Kenosha, you know as well that a jury found Kyle Rittenhouse not guilty of murder and of all other charges after he testified in his own defense. And again, since that time has become something of a cause célèbre in right-wing organizations who have touted him not only as a Second Amendment advocate, if you will, with respect to firearms, but also someone generally in the public eye regarding civil unrest and the social conditions of America in 2020, 2021, 2022, and certainly to this day. Well, Kyle Rittenhouse back in the news again this past week. This time in federal court in the Eastern District of Wisconsin, in a case that's pending before Judge Lynn Edelman. Judge Lynn Edelman is a United States District Court judge in the Eastern District of Wisconsin, and Judge Edelman has before him a lawsuit. It's a civil lawsuit, not a criminal case. Kyle Rittenhouse cannot be retried for that offense conduct. But what has happened is that in the wake of all of those activities, including his acquittal for those murders, those offenses in Kenosha County,
a lawsuit is filed by John Huber. John Huber is the father of one of the two victims of Kyle Rittenhouse. And the lawsuit also identifies some city officials, some police officers, as people who are responsible for the wrongful death of Mr. Huber's son, rather. And so in the course of reviewing this litigation brought to allege a wrongful death, again, a civil lawsuit, the allegation is that Rittenhouse conspired with police officers to intentionally cause harm to the protesters who were marching in reaction, as you may recall, to the shooting of Jacob Blake that happened not long before those protests in that city. And during the course of this lawsuit, the allegation is that by virtue of this so-called wrongful death, that Mr. Huber and presumably other members of his family civilly damaged by virtue of what Kyle Rittenhouse did. Rittenhouse, as I indicated, an Illinois resident, had driven to Wisconsin and was a minor, age 17 at the time, now plainly an adult. So what happens is, in this particular case, that the defendants, including Rittenhouse and the other city officials and police officers, file a motion to dismiss. And so there's no cause of action here. Nothing to see here, Judge. Dismiss this case, dismiss the wrongful death action that has been brought by Mr. Huber on behalf of his fallen son. And the judge says no. Judge says no. Under the federal civil rights laws, he permits this lawsuit to go ahead. In the ruling specifically, Judge Edelman said that Huber's death could plausibly be regarded as having been proximately caused by the actions of the government defendants. Goes on to say Huber was killed after Rittenhouse was running after he shot and killed his first victim in the parking lot of a car dealership, and Huber hit Rittenhouse with a skateboard to disarm him. All of those facts that, of course, recalled very well by all of us who were following these events in that area at the time. After falling to the ground, again, Edelman not only recounts these stories, but also pulls them from the news accounts of the time. Rittenhouse fatally shot Huber and wounded another protester. His name is Gage Grauskowitz, who had also filed a civil lawsuit against Rittenhouse. Interestingly, Huber's lawyers, again, the ones who were advocating for this wrongful death action, had encountered some very significant problems in locating Rittenhouse more recently to serve him with this civil lawsuit paperwork. They eventually served him at his sister's house. Rittenhouse's lawyers in this civil wrongful death action had claimed that the case should be dismissed in addition to being on the merits, but also because he was not properly served. And the judge also dismissed that claim as well. So significant that a federal district court judge in Milwaukee, in the Eastern District of Wisconsin, is now permitting this lawsuit, this civil rights lawsuit, to go ahead against Kyle Rittenhouse and others among the defendant group for the wrongful death of one of the individuals who was killed as a result of that social unrest, and in particular Kyle Rittenhouse's murder and his shooting of those victims at that time. We'll continue to monitor that as well as the civil lawsuit goes ahead. Plainly, next steps in that case, as in many others, involving discovery, the taking of depositions, which means that Kyle Rittenhouse and city officials, the police officers, others involved who may have relevant information about what happened that night, all of them can be deposed, again, not in a criminal proceeding. This is not a grand jury. This is not a criminal trial. But during the course of discovery, in anticipation of a civil trial, that will proceed in the months, perhaps even years ahead. And at some point down the road, Judge Edelman perhaps will schedule the entertaining of a scheduling and a trial in his own court there in the federal district court. And that could proceed at some point down the road on the merits of this case, could also be the subject of settlement. And so we'll continue to watch that case as it goes forward. Again, seeking wrongful death judgment, all of that related to judgments in the form of money that could in fact be granted to Mr. Huber and others for the violence with respect to his son. When we come back, more stories about the rule of law in America. Stay with us for that discussion.
When you see the man do it. sister. Oh, done seen enough. Oh, moving the shoulder. Got his head moving side to side.
And we are back for this final half hour, always taking your phone calls here at Morning Cannolis. That is my wonderful producer and I at 844-967-2789. Join us for the discussion, offering your perspectives, your questions, your comments about these and other stories that may be in the news on your personal dockets. We're going to talk now about another civil case, this one also pending in a federal appeals court. We talked in the previous hour about this criminal case pending before the Fifth Circuit Court of Appeals in the South, finding that Section 922 of Title 18 is unconstitutional, a real blow to the safety and security of America when it comes to enforcing laws and prohibiting people who engage in domestic violence from possessing and using weapons. We'll see what happens with that one as it goes, presumably, to the United States Supreme Court. We've got another case on our docket this morning. This one comes out of the Third Circuit, basically eastern states, and in particular New Jersey. New Jersey is the principal location, not the only one, but the principal location of Johnson & Johnson. You know them well for all of their medical products and other things that they produce, including a talc-based powder. I suspect that some, not all of you, have used in various iterations, various productions of that coming out of Johnson & Johnson and its products placed on the commercial tables and shelves for purchase. What happens here is that about 38,000 people come forward, and they say that this particular product, among those powders that Johnson & Johnson produces, there's certain one of them that causes cancer. And J&J has repeatedly denied that allegation. So they've said it's not true. And so some of those lawsuits have proceeded around the country. J&J has recently done something that was the subject of this Court of Appeals decision by the Third Circuit. Again, a 3-judge panel coming out of the Third Circuit Court of Appeals. And in particular, reviewing what happened in the bankruptcy court in one of the district courts there in New Jersey. What happens is this. We know that J&J places about $2 billion through a trust to pay some of these claims, an amount that many of the victims say is going to be insufficient. We also know along the way that J&J has an equity value about $400 billion with a B, AAA credit rating, and about a $31 billion in cash and marketable securities. So a company that is wealthy and has some substantial financial holdings. What the J&J authorities and leadership does is this. They create something called the LTL Management Group, LTL Management, and they place all of these legal liabilities presented by these 38,000 lawsuits by these claimants of injury under this talc powder administration, this talc powder use. They place all of the liabilities in LTL Management, and then they file in the United States Bankruptcy Court in New Jersey for Chapter 11, which basically means for reviewing the debts that this particular LTL Management may now have to all of these claimants. And again, for a company to do this, this is the focus of the Third Circuit Appeals Group. And they take a look at this and they basically say, no, you can't do this. The court says because LTL was not in financial distress, it was simply the holder of all of these potential liabilities. It cannot show, the court said, that its bankruptcy petition served a valid procedural purpose and that was filed in good faith. And as a result of this, sending a very strong message that what J&J has done, Johnson & Johnson has done, in terms of trying to evade responsibility by dumping all of its potential liability into this shell company, if you will, and then seeking to reorganize under Chapter 11, that is not legal. And the Court of Appeals basically says, we know that what you're doing is simply an attempt to try to limit your exposure We know well that under the bankruptcy courts, and an organization files for bankruptcy, in this case, J&J through its subsidiary, this LTL Management, creditors typically have to negotiate collectively with the debtor in pursuit of a settlement, often for pennies sometimes in the dollar in the case of litigation. So this is an attempt by J&J to try to evade the responsibility that would otherwise have to these talc powder victims, these 38,000 victims who maintain that they were affected by and affected dramatically by their own cancers as a result of their use of this talc powder. The Third Circuit once again saying you can't do this. And why is it significant? Why is it significant that J&J told, no, the bankruptcy itself will be dismissed. You, Johnson & Johnson, have this huge amount of money from which you can, in fact, pay if indeed there are findings in other courts that you're responsible for this. Why is this significant? Well, again, it shows the ways in which the courts are properly and then improperly used by some parties. This is a real slap on the wrist, not only for J&J, and it's more than a slap on the wrist procedurally, because it sends them the news that they cannot use the bankruptcy court for this illegitimate purpose of trying to evade the financial judgments that would come to them by virtue of the prosecutions, the civil prosecutions against them. We have seen this kind of thing in at least two other areas. In 2021, you may recall that a judge dismissed the National Rifle Association's Chapter 11 bankruptcy, the same kind of thing, because the NRA, by its own admission, by its own pleadings in matters before that court, wasn't facing any financial troubles. It may, in fact, be in that situation now, but at that time, a couple of years ago, there was not evidence in the record to show that that was the case. The NRA has sought the protection of the bankruptcy court, again, in an attempt to delay a lawsuit by the New York State Attorney General. You know her name, and she is Letitia James, that was seeking to disband the organization. And the judge at that time, invoking the same rules, the same fundamental rule of law principles that the Third Circuit has now applied as to Johnson & Johnson, said you can't run into bankruptcy court as a way of getting rid of your liabilities, especially when you have enough money to pay. Bankruptcy court is not a safe haven, if you will, for doing that. That's what the court said in National Rifle Association. That's what the court said to Johnson & Johnson just this past week as well. There's another situation similar to this, again, underscores the nature of the challenge of using the courts properly in the United States of America. 3M, you know them well, the conglomerate, had placed something called Aero Technologies, a subsidiary of it, once again, into bankruptcy. And it was hoping at that time to process, through this bankruptcy process, to speed a settlement of more than 230,000 lawsuits from military service members who had accused Aero earplugs of causing hearing loss. And once again, the court said you can't do that. The bankruptcy court is a way of reorganizing debts. It's a place where you can, in fact, discharge debts if indeed you are in real financial problem. 3M, at that time, once again, not the case. And so there again, the case was dismissed, thrown out of bankruptcy court, and the judge saying, cannot use the court for this illegitimate, inappropriate purpose. The case involving Johnson & Johnson, of course, first and foremost, hugely important, hugely significant for the plaintiffs, those 38,000 people who claim that by using the Johnson & Johnson product, this talc powder, that they have gotten cancer. And those claims can now be pursued in the trial courts, the claims made without the protection, if you will, that Johnson & Johnson sought of the United States Bankruptcy Court. We know as well that others, not only the NRA, not only Aero Technologies and 3M, we've also seen people like Alex Jones threaten to go into bankruptcy as a way of evading the billions of judgments also against him. Likely the courts to follow this continuing precedent set by the Johnson & Johnson case, other cases saying that you cannot run into bankruptcy court as a way of evading your otherwise important responsibilities out there. That, again, coming from the Third Circuit, an appropriate decision by the Third Circuit, ensuring that corporate America is held responsible not only for its conduct, if it is proven to be so in a trial on the merits of these claims, but also doesn't run into court to try to evade the responsibility when it has sufficient monies to satisfy those judgments if indeed they are ultimately entered. And so another important case coming out in an appeals court. And now, as a part of our continuing review to this day of some significant events, another significant prosecution, this one in New York City. This is also in federal court, in the U.S. District Court in the Southern District of New York. This case coming out once again in the wake of a significant investigation conducted by the Federal Bureau of Investigation against an individual named Charles McGonigal. McGonigal is his last name. He was a former chief of counterintelligence for the FBI, and the allegations against him now by prosecutors in the United States District Court in the Southern District of New York are that he was working secretly for a fellow named Oleg Deripaska, and he was investigating this Russian entity, this Russian person, at the same time that he was also getting benefits from him, getting paid by him. So what we have here is a case of an internal employee of the FBI now charged with aiding this very significant oligarch. Oleg Deripaska, many of you recall, was also the subject of a lot of inquiry. He was the subject of an indictment under the so-called Mueller investigation, remains under that indictment, and during the course of that Mueller investigation and other proceedings by the FBI, identified as one of the people who should in fact be charged federally. So what we have here again is this former FBI official in New York overseeing some of the agency's most secret and sensitive counterintelligence accusations, being accused of taking money from the very person that he is supposedly investigating. Very significant prosecution charges against him. Federal prosecutors said that McGonigal, who is 54 years old, specifically broke federal law by agreeing to help Deripaska, who was indicted himself, as I said, on sanctions charges, investigating a rival oligarch and trying to get off that sanctions list. The charges, once again, are hugely serious. It's a rare accusation against a senior FBI official, and they demonstrate again, as we saw in the time of the Mueller report, that the reach of Russia's oligarchs can extend perhaps even into the heart of American law enforcement. The indictment, which was unsealed the week before last, again, returned by a federal grand jury, reviewing all this information and determining in the end that there is probable cause to believe that these offense conduct, this set of offense conduct, did in fact take place, that he took about $225,000 in secret cash payments from this Deripaska fellow who had served with Albania intelligence previous to that. And McGonigal, of course, again, while he's doing this, concealed that relationship, concealed the fact that he was on the payroll of the very person that he was supervising, investigating as a part of his investigative work. In an email to the FBI employees, Christopher Wray, who we know is the present director of the FBI, identified once again the great challenge that this prosecution presents to the FBI, finding again internal to its own people that this has happened, but also noting that the great majority of FBI officers and special agents and staff do not engage in this sort of behavior, which really is traitorous in many ways. It is contrary to the very mission and purpose of the FBI, contrary certainly to the best interests of the United States of America. In an email to all of the employees of the FBI, when this indictment was unsealed and presented into the public domain, Christopher Wray called the conduct of the defendant here, Charles McGonigal, entirely inconsistent, he said, with what I see from the men and women of the FBI who demonstrate every day through their actions that they're worthy of the public's trust. Again, those are the words of the FBI director. Again, charges like this are very rare. In 2018, Andrew McCabe, the former acting and deputy director, was referred for prosecution after the Justice Department Inspector General accused him of misleading investigators, but that case was eventually dropped. In 1996, a senior official also charged him in connection with a deadly 92 standoff, and that case likewise pursued in the courts. When we come back, we'll talk more about the importance of this case and other matters within the rule of law ambit of our nation in 2023. Stay with us for that.
Segment this morning, February 4th, here at Morning Cannolis, right before the break, talking about this very disturbing prosecution announced just about a week or so ago against Charles McGonigal, who was former chief of counterintelligence inside the FBI, charging him basically with violating not only the trust placed in him, but also some very specific federal laws prohibiting, obviously, this kind of conduct. Significant as well that a second man named Sergei Shestakov, 69 years old, he was a former Soviet and Russian diplomat who became a U.S. citizen, charged along with McGonigal. Shestakov worked as an interpreter in the federal courts and the U.S. Attorney's offices for the southern and eastern districts of New York. Again, charged along with McGonigal for this kind of conduct. I mentioned right before the break that it is rare, but it does in fact happen from time to time, that we have individuals inside the FBI. We've seen some CIA prosecutions as well for people who violate the trust, the oath of office placed in them. And I mentioned that there was a case. It was pursued in the federal courts. 1996, a senior official was charged with obstruction in connection with the deadly standoff at Ruby Ridge, which you may recall was this 1992 standoff, remote section of Idaho. About 2 decades before that, an acting FBI director and a deputy, along with another official, was charged with conspiracy for some break-ins at the homes of political dissidents without warrants. And again, all of those kinds of things underscore the violations of basic trust that unfortunately can happen. At the other extreme, there is the statement made again by the director of the FBI, directors of FBI, whenever these kinds of charges come forward, that confirm for America that the great majority of FBI special agents and staff and officers are good people who understand their oath of office. And indeed, the last part of this report on McGonigal was the amount of shock that that was seen among former colleagues when they found out that McGonigal had done all of this. Many of them said he primarily investigated Russian counterintelligence and espionage. Shocking, they said, to see that the very thing that he was investigating was the very thing that he was also engaged in, getting money from Deripaska for his relationship of a highly inappropriate nature. McGonigal now facing some very serious charges and also facing some very serious prison time if indeed he is convicted of those charges in the federal district court in the Southern District of New York. And that brings us to our final story of the morning, and that is in the Manhattan, in New York, but in a state court, and not a federal court, a state court there. We know just from this past week, the Manhattan District Attorney's Office once again pursuing Donald Trump. Information released that the district attorney there in Manhattan, his name is Alvin Bragg, is apparently nearing a decision about whether to charge the former president, Donald Trump, with his role in paying some hush money to a porn star during the 2016 presidential campaign. And we know this because, in part, he is presenting evidence of this to a state grand jury. Again, not a federal grand jury, but a state grand jury that has been convened to review all of this. And this is a story that we have spoken about on this broadcast and in others of Civic Media way back in 2016 when payments were made through Michael Cohen, who was the former president's principal handler, his fixer, his lawyer, to provide information, provide payments to at least one, if not two people who purportedly had a sexual relationship, an affair with then-candidate Trump during the course of the election. And we know as well, in the wake of those allegations,
We know that Michael Cohen actually went to prison, went to federal prison for his involvement in those payments to those people, that being a federal violation, a violation of the federal election laws. But we know also that in the wake of the Michael Cohen prosecution, nothing more happened in the federal venue. An awful lot of people scratching their head, wondering about what happened, and an awful lot of information out there now suggesting that Maine Justice stopped the further investigation of that matter federally. And now, in the wake of this recent news coming out of Manhattan, being picked up by the state prosecutor, the Manhattan DA, if you will, who is now looking at it again to see if there are violations, not of federal law under the federal elections law, but whether or not there are state violations having to do with finances and accounting and reporting on those monies. Significant, of course, that this investigation, initiated again by Bragg, apparently nearing some decision about whether or not this event could support charges against the former president, being pursued again in front of a state grand jury there in Manhattan. We know as well that Bragg was responsible through his prosecutors for the recent criminal conviction of the Trump Corporation. Again, same court, same kind of thing, that for basically tax fraud under the state, New York State tax code. And we know as well that Bragg was responsible for the prosecution of the chief financial officer, Alan Weisselberg. All of that coming out of this same prosecution office recently in the Manhattan court. This one, obviously, following up on that, much related to it because of its focus on finances and on the possibility that monies that were paid by the former president, perhaps by members of his family, his son as well, funneled through Michael Cohen to a fellow named David Pecker, who is the former publisher of the National Enquirer, basically to stop this story from being published about the then President Trump's, as he was a candidate, his candidacy being marred perhaps by reporting of his affairs with these women. And so again, significant because the state now picking up on a situation where the federal government did not pursue similar charges. Certainly looking forward to what the state grand jury there may do down the road when it comes to further prosecutions. In this area generally, the Trump Corporation, of course, we know, as we always state, that all individuals are presumed innocent until proven guilty, but an awful lot of things there in Manhattan percolating up. We know as well that the state attorney general as well, we mentioned Letitia James as well, likewise looking at a civil case against the Trump Corporation and Trump companies, including the family, seeking about $250 million for their involvement in some valuations matters as well. And finally, as we go into our last minute or so here on Morning Cannolis, reminder of important Supreme Court cases coming up. February 21 and February 22 this month, 2023, the United States Supreme Court taking a look at this case that I mentioned before about the liability of website providers, online platform providers, when it comes to postings of its users. We'll talk about those and other cases, future broadcasts right here on Morning Cannolis. For now, we encourage you to hear in our future broadcasts more about all of these stories and more. Stay with us every Friday morning, every Saturday morning from 9 to 11 right here on the broadcast stations of Civic Media. Thanks for joining me this morning and every morning in the future of America, the future of the state of Wisconsin.